I'm the managing partner of the Mulcahy Law Firm in Phoenix, Arizona, and I will be your instructor here today. I have enjoyed representing as their legal counsel HOAs and condominiums in Arizona for over 25 years. I can't believe it's been that long, but it has. And my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also serve on my HOA board, and I have for many years. So I think I kind of bring an interesting perspective to these classes. And don't fret if you are a board member. Of course, I work with board members all the time and property managers as I'm advising them about running their associations. But I also had a little stint as a disgruntled owner in association that I live in. I was on our board for a number of years, and then I was off our board for about 10 years. And during that time, I was unhappy with how things were running. So if you're here as a homeowner today and you're not happy with how things are running in your association, I really do understand that perspective too. So let's just get started. We have a great class for you today. But before we do that, we are going to ask you a question. So we're going to be launching a poll here to find out who our audience is today. And so our poll question number 1 is, let us know your current role. Are you a board member? Are you a manager? Are you a homeowner, interested homeowner in the community, or are you other? And we're going to let those poll results come in. And while we're doing that, I'm going to talk a little bit about what's going to be on our agenda here today. We're going to be talking about the legislative update and the 2022 legislature and the 5 laws that were passed this year. Okay, let's get back and talk a little bit about the answers to our poll. So we have a really great turnout here today. We have 58% of you are board members, 9% are managers, and 33% are interested homeowners. So thanks so much, everybody, for being here today. We really appreciate that. And we're going to get right into our presentation. Okay, let's talk a little bit about what happened in our legislature this year. The 2022 legislature was one of the longest legislative sessions in history. It lasted 167 days, and there were a number of HOA and condo bills introduced this year. I would say that this year was the first post-COVID big year for HOA and condominium laws to be introduced. We saw over 25 bills introduced this year, which is really kind of an unusually high number. And ultimately, only 5 bills passed and were signed into law by the governor. And we're going to just take a quick moment here and talk about what those 5 bills are and what they mean for your associations. So the first bill talks about artificial grass, and that is House Bill 2131. That is going to add a section to the Planned Communities Act only. And that will be in 33-1819 if you want to know the new codified section. One thing I want to mention too is that all these laws are going to be going into effect on September 24th. So that'll be very soon. So the first bill talks about artificial grass. And the bottom line on this bill is that no matter what your association's CC&Rs, rules, architectural guidelines, landscaping guidelines state, if a planned community allows natural grass on a member's property, which most do in Arizona, an association cannot prohibit, after September 24th, an owner from installing or using artificial turf on that member's property after the time of developer's control. So there's a couple things that have to kick in before this law would apply to your association. Number 1, it has to be for planned communities or HOAs, right? So this law only applies to planned communities and HOAs. It only applies to an owner's lot, and it only applies to associations that are post-developer control and associations that allow natural turf or grass already on an owner's lot. So in those cases, if an owner wants to convert their natural, turf, their grass to artificial turf, we cannot, as an association, prohibit them from doing that. Now, of course, they have to go through the whole architectural review process. And there are some, special parts of this law that you need to be aware of that we can manage and control, what they're installing. So the association can make reasonable rules regarding artificial turf guidelines. So If your association wants some sample rules, our firm has prepared some sample ones. We can give them to you for free. If you email me at bmulcahy@mulcahylawfirm.com, or you email Bruce with the city of Scottsdale, and he can get your email to me, and we'll be sure to send you the sample rules. So what are the type of rules that we're putting into place for this new artificial turf law? We can put rules into place regarding the quality, the type of installation that's done, and the appearance of the artificial turf. So the rules can address, basically quality control, where they're placing it on their property. It also can discuss the percentage of property that may be covered with artificial turf, and it's basically it can be to the same extent as natural grass would be used on their property. So bottom line, the association can pass rules. We've got some sample rules. If you want them, contact me or ask Bruce to give your information to me, and we will send you out some sample rules at no charge. The plan community can also require a few other things as they're looking at these artificial turf applications that come in. After they've approved the artificial turf and the owners installed it, if the artificial turf starts to create a health or safety issue, the association can mandate that the artificial turf be removed. It's also, if the artificial turf isn't being maintained, the association can require replacement or removal of the artificial turf. And again, it'll be really important that those rules that you implement have some standards and guidelines in terms of, what the typical maintenance procedures would be for the artificial turf, and so that we can enforce this. A planned community association can prohibit artificial turf in a couple very few select situations. So if the artificial turf, the owner wants to install the artificial turf in their front yard, and this is the area that the association maintains, the association can prohibit them from doing that. And that just kind of makes sense, because if the front yard of an owner's lot is maintained by the association already, the association can't be expected to have additional maintenance requirements just for your lot because you want to install artificial turf. And so that's important to note. There aren't that many associations that fall into that category where the association maintains the front yards, but there are some in Scottsdale, and we represent them, and I know that exists. So you wouldn't be able to do that in those circumstances, install artificial turf. Another area that you wouldn't be able to do that would be if the planned community already prohibits new installation of natural grass on a member's property. In that case, the association would also be able to prohibit the installation of artificial turf on that property. And then finally, if the planned community has unique vegetation, like this is an NAOS area, or geological characteristics that require preservation by the association or by the owner, and in which the viability of those characteristics is protected, supported, or enhanced as a result of continued existence of those natural landscaping materials, the owner would be able to convert those special areas that have unique vegetation and geological characteristics, like an NAOS area. They would be able to convert those areas into artificial turf under the law. One little important point to mention at the end is that associations need to be aware of this law, and if they're sued because they violate this law, the prevailing party in a lawsuit will be entitled to their attorney's fees as determined by the court. Of course, attorney's fees would have to be reasonable, but there's a penalty right there in place that if the association isn't allowing artificial turf in instances where we have to, the association will be penalized if there's a lawsuit, and will have to pay the prevailing party's attorney's fees. Just kind of a closing note on this first bill, and this is kind of one of the longer ones we're going to be talking about this morning, is that this is just consistent with the times. The state of Arizona Department of Water Resources already has a water management plan in place. We're in phase 3 of that, and associations really need to start looking into how they can conserve water going forward. And so this is just a step in that direction, where if owners want to have artificial grass on their property in a planned community, associations will be prohibited from, not allowing that. And remember, just kind of a side parting note, your associations really should be evaluating how you can conserve water. I know the city of Scottsdale is recommending not overseeding this year and thinking about, converting some of your natural grass turf to desert landscaping is a very popular trend right now throughout the state. And you may want to check in and see if there's any grants that might be available that the city of Scottsdale might be offering to help you with any turf conversion process to desert landscaping. Sometimes there are different times of the year there are grants available, and it can be a way to help share the cost for converting the regular turf to desert landscaping. Again, like I said, we have some artificial turf guidelines that we are happy to give to you. Just contact me by email or Bruce, and we'll be happy to provide them to you. Okay, let's talk about another new bill, the second new piece of legislation that's going to be going into effect on September 24th. And this deals with peaceful assembly in an HOA or condo, political signs, and community activity. And again, this is just another sign of the times bill, right? We know that in 2020, we had a very active election year, and we are going to see another active election year this year in 2022. If you're driving around Scottsdale right now, you're probably seeing a lot of political signs. And I think this bill is directly a result of the increased amount of political activity in our state and our country. Okay, so first things first. This new bill was going to go into effect September 24th before the election cycle coming up in November. And it applies to planned communities and condominiums. So the first part of this bill talks about an owner's right to peacefully assemble on the common areas. Now, it's kind of strange that our legislature is mandating this, because if you really think about it, owners already have the right to peacefully assemble because they have an easement to use the common areas in the association. But our legislature thought it was important that they make specific, mandates on this. So, just the information on this new law is that if, no matter what your documents state, if an owner wants to peacefully assemble or use the common elements or common areas, they should be allowed to do that. However, the association can place reasonable rules or restrictions on that peaceful assembly. So typical rules that we might see would be that, limiting the number of people that might be able to peacefully assemble at the pool to maybe like the maximum occupancy with limits or something like that. An individual owner or group of owners can peacefully assemble and discuss matters related to the association, including how they feel about the board, like board elections, board recalls, any ballot issues that the board may be facing, any revisions to the association's documents, how the property maintenance is going, safety issues, or really any other association matter. So this time to peacefully assemble in the association can be on basically anything pertaining to association matters. The owner can also invite one political candidate or one non-owner guest to speak to an assembly of owners about matters related to the association. And the association has a really weird requirement under this new law. If the owners want the association to place notice of their peaceful assembly on the association's bulletin board or on the association's website, the association's board must do that. And so that's important for the board to know. If you get a group of homeowners that are having a peaceful assembly meeting and they want the board to post notice to the community that this is happening, the board does need to do that. Now, that doesn't mean that the board has to, send out a mailing and, spend postage on this. No, it just means that if you have a bulletin board or you normally place signs at the community in certain locations, you would be required to do that if the owners are requesting you to do that for their peaceful assembly meeting. I think it also extends to the association's website. If the owners specifically request that this be done, I think it should be placed on the association's website. Okay, so that's the first part of the law. It's going to be really interesting to see how this goes down in our industry. Sometimes when we overthink these new bills, it really ends up not being a big issue. But I do think that we're going to see in our associations in Scottsdale and throughout the state, owners being more active and asking for the right to peacefully assemble to talk about association issues. And I really encourage boards that if this happens, to have a positive attitude on it and to listen, because a lot of times when people are unhappy or upset about things in their association, the board really needs to put their antenna up and listen and try to understand what the concerns are and address them. Okay, let's talk next about the next part of this new law, which talks about association-specific political science. And this part of this new law applies to planned communities and condominiums. And it basically says that no matter what your documents state, an association cannot prohibit or unreasonably restrict the indoor or outdoor display of an association-specific political sign or the placement of a sign on that owner's property, including any limited common elements that they may have that are their exclusive use areas, or like their front yard, if it's planned community and their lot, they can put these association-specific signs. And so what would be some examples of this? Maybe board member elections, board member recalls, vote against the CC&R amendments, vote against the special assessment, vote in favor of the special assessment. These type of association-specific political signs are going to need to be allowed to be placed on that owner's property or their limited common elements if they're a condominium. We can place reasonable rules as an association regarding the placement, location, and the manner of display regarding the political signs, but we can't do certain things. And so I want to make sure that you're aware of that. We can't prohibit the display of association-specific political signs between the date that the association provides written or absentee ballots to unit owners or lot owners. So from the date that we give them the notice, the written or absentee ballots to vote on an issue, from that day until 3 days after the election or whatever the issue is being voted on. So there's a window there that they can put up these signs. We can't limit the number of association-specific signs, except that the association can limit the aggregate total dimensions of all association-specific signs to not more than 9 square feet. So all those signs together, are going to have to not exceed 9 square feet. We can't make them be commercially produced signs. So somebody can just get out a big Sharpie or a magic marker and make their sign regarding the association issue. So we can't make them be professionally manufactured, and we can't prohibit them from using both sides of the sign. Last, we can't regulate the number of candidates supported or opposed, or the number of board members supported or opposed in a recall, or the number of ballot measures supported or opposed on an association-specific political sign. So finally, the last part of this is that we can't make any other regulations regarding these association-specific political signs regarding the content of the political sign. Also, we can say no profanity, no discriminatory text, images, or content based on race, color, religion, sex, familial status, or national origin as prescribed by federal and state fair housing laws. So another really interesting bill that we're seeing this year, part of this bill, is if owners want to put up political signs regarding the association on their property, there really isn't too much we can do about it. There are some limitations on, how much they can have, how many they can have in terms of it can't exceed 9 square feet total, all the signs, and they can't, contain discriminatory or profanity on the signs. But really, other than that, anything goes. So it's important that you know about that, because you may see that at your next association big issue or board election or removal or whatever, and you want to make sure that you comply with the law. Let's see, the other part of this new law is that it adds to the definition of a political sign that's already in the Planned Communities Act and the Condominium Act, a sign regulating any activity to elect or remove a condominium director, or in support of or opposition to a measure that requires a vote of the association membership, is covered as a protected political sign under the Condo Act and the Planned Communities Act. Okay, so Another interesting bill, sign of the times. First we're seeing bills that are going to be dealing with conservation, like the artificial turf bill. Then we're seeing signs that are going into political issues, right to peacefully assemble in an association, right to have political signs regarding your association business, all really interesting hot topics right now in our state and our country. Another bill, the third bill we're going to be talking about, also applies to planned communities and condominiums, and this is another sign of the times bill. This definitely is a direct result of the pandemic, and basically this bill talks about first responder flags. And this bill says that no matter what your association's documents state, a planned community or condominium cannot prohibit the outdoor display of a first responder flag. This flag, however, can incorporate the design of one or two other first responder flags to form a combined flag, and a blue star service flag or a gold star service flag. So first responder flags, blue star service flags, or gold star service flags are all allowed now under this new law. There's different, intricacies about, what's considered a first responder flag. And we're going to be sharing something with you in terms of more information and more specifics on that if you have any questions on that. Let's see, the other two laws that we're going to be talking about. We have the next one that talks about condominium termination. This is the fourth law. This also will be going into effect September 24th. We're really not going to see this applied to many associations, especially in Scottsdale. This basically just talks about the procedure to terminate a condominium. We really saw a lot of this in the West Valley when Grand Canyon University was expanding and they were looking for additional land for their campus and additional dorms. We don't typically see this issue pop up hardly ever in Scottsdale. But basically there's a new procedure to terminate a condominium. And what does it mean to terminate a condominium? It means just to make it no longer a condominium. Maybe you're trying to turn it into an apartment complex, or you're trying to convert the use entirely. And so if you're one of those associations that is trying to do that, there's a couple things that you need to be aware of. A condominium can be terminated. So a condominium that was created prior to September 24th can be terminated only by agreement of 80%, so 80% of the unit owners, or any larger percentage if the declaration has a larger percentage. There are some exceptions to that, like if the land is being taken by eminent domain, or if the declaration calls for a smaller percentage, but only if the units are used for non-residential use. So 80% would be how you terminate your condominium if you were created before September 24th, 2022. After that, you need to have 95% of the owners to agree to terminate the condominium. So if the condominium was created on or after September 24th, it goes up to 95% versus 80%. Again, that's just kind of it's not a law that's going to apply to everybody. It's only condominiums, and it's only if you want to get rid of your condominium, which I'm sure that most of you are not on that boat. Okay, the last law that we're going to talk about this morning that is going to be going into effect on September 24th talks about vacation rentals, short-term rentals, and kind of an increase in the enforcement efforts to better manage short-term rentals. This is a sign of the times law because for those of you who've been following legislation in Arizona regarding associations over the years, you'll know that in 2016, there was an enormous change in how short-term rentals were going to be handled in Arizona. The legislature passed a law stating that, cities, towns, municipalities, and counties were no longer going to be able to regulate short-term rentals, and that if associations wanted to implement rental restrictions for short-term rentals, they needed to put that in their CC&Rs. And as we all know, it's really difficult to get CC&R amendments passed. So it really was a burden on associations if they didn't already have short-term rental restrictions in their documents. So let's fast forward 2016 to today. really by 2019, the summer of 2019, we were seeing just an incredible increase in the number of short-term rentals throughout our state. I think Scottsdale has 4,000 plus short-term rentals in Scottsdale. That's huge, enormous. And what we started to see by the summer of 2019 is that there was a lot of people that were very upset about the long-term effects of the law from 2016, which took away city, states, and municipality, or excuse me, city, county, and town ability to regulate short-term rentals. And the governor in the summer of 2019 said, hey, this isn't working. He was in Sedona, and there were a number of quotes that were taken when he was visiting Sedona at that time. And he said, I agree, this isn't working. We're going to go back to the drawing board with the 2020 legislature, and we're going to address this problem. Because so many of these cities were having such a large conversion of housing to short-term rentals that, people who lived in those cities couldn't buy houses anymore because of that. So, well, then the pandemic hit in 2020, and that was really like a COVID legislature year where it really wasn't much accomplished other than the budget was passed. And, we had so many other problems in our state, along with the rest of the country, dealing with the pandemic. So nothing was done in 2020. 2021 was kind of what I'm going to call a recovery COVID legislature. And we didn't have a lot of new bills last year pertaining to, HOAs and condos. So this year was the time to address short-term rentals. So the legislature this year did pass some pretty extensive requirements, and most of them fall on cities, towns, municipalities, and counties to enforce. And so this law applies to planned communities and condominiums, and it sets forth the different ways in which a city or town, or municipality or county can regulate vacation or short-term rentals. And so here's the different ways that they can regulate short-term rentals starting September 24th. Number one, the city can require the owner of a vacation or short-term rental to provide emergency contact information for the owner who is responsible for responding to complaints or emergencies. And the city can impose a pretty hefty penalty of $1,000 if the owner fails to provide the contact information. And that can be $1,000 every 30 days. So that's like, whoa, that's a huge punch. And so basically, I think that the rationale for this part of this new law is that the city wants to have who the decision maker is in the event of an emergency regarding the short-term rental right at their fingertips, their emergency contact information. So if there's a problem, the city can reach out to them. And there's a pretty hefty penalty if they don't provide that. But the city, of course, has to put that into an ordinance for that to be something that can be enforced. The next thing that the city can do is require the owner to maintain a local regulatory permit or license to have that short-term, rental or vacation rental. And many cities kind of already had that. But it's kind of something that is, if your city didn't already have that, now that's something that you can require. The third thing a city can do is to require, before offering a short-term vacation rental for rent for the first time, the owner has to notify all single-family residential properties adjacent to, directly, and diagonally across the street from the property that, guess what? A short-term rental or vacation property is moving into that property. So it provides a notice element to the neighbors that, hey, we are converting our property into a short-term rental property. And it's basically going to be everybody surrounding the property that wants to do this. The other thing the city can require is that the owner display the local regulatory permit number or license number, if any, on every advertisement for the vacation or short-term rental for that property. And then lastly, it can require the vacation rental or short-term rental to maintain appropriate liability insurance to cover the vacation or short-term rental in the aggregate of at least $500,000, or to advertise and offer each rental on an online marketing web place like a Airbnb or HomeAway or VRBO, where they provide that coverage or additional coverage. The bill also talks about the fact that the city or town can deny issuing a permit to somebody who wants to convert a property to a short-term rental for any of these reasons, for not providing the information that we just talked about, like the contact information, or getting the permit, or not listing the permit number on their advertisement, not paying the license fee. If at the time of the application, the owner has a suspended permit or license for the same vacation or short-term rental, it could be denied. If the owner landlord provides false information, can be denied. Or if the owner is a registered sex offender or has been convicted of any serious felony in the last 5 years, there can be a deniance of the permit to the person who is requesting it on behalf of the property, which would be the owner. And so again, kind of what we're seeing on this, is, and the cities can adopt ordinances to reflect all of these new changes in the state law. And so what we're seeing now is the state is shifting the burden for the regulation of short-term rentals a little bit back to the cities or towns by giving them the right to, implement all these different ways to regulate short-term rentals. A couple of thoughts to think about if you are an association or you're an owner or manager as you're navigating the short-term rental issue in your association. So if you have a bad short-term rental, some tips on things that you can do would be, number one, you need to start documenting the violations by the tenant, and documenting them to the owner. So keep track of all the different things that the tenant might be doing that are violating, your association's restrictions, whether it's having wild parties, violating parking rules, bringing glass into the pool. So the association, should start documenting that with written evidence and pictures. Also, when there are complaints being made, you need to notify the police. If there's anything that requires police involvement, noise issues, etc., you should be documenting that by contacting the police, and also reaching out to the city of Scottsdale if there's a really bad situation with a vacation rental or short-term rental. Make them aware of it so that then they can use that contact information to reach out to the owner in an emergency. Some important things to note about the city of Scottsdale short-term rental. So there's actually a special group, short-term rental group that is kind of overseeing short-term rentals in the city of Scottsdale. There are 4,320 short-term rentals in the city of Scottsdale. That's like huge. Okay, that's been up since I talked about short-term rentals last spring for the city of Scottsdale. Of those 4,230 short-term rentals, only 2,289 have provided contact information to the city. So if you're an owner landlord who has a short-term rental, you really do need to reach out to the city and give them that information, especially because the penalties could be really significant for you at $1,000 per month. It's our understanding right now that the city of Scottsdale is working on an ordinance in light of this new law. The ordinance will likely be adopted here this fall in 2022 and will be likely become effective later this fall, probably in November. So there may be a little bit of leeway in terms of how much longer these short-term rental owners have to register the property, but it's a very short leash and it's around the corner for sure. The city of Scottsdale is looking at a possible deadline for all short-term rentals to be licensed pursuant to the new law by Christmas Eve. And so just keep checking the city of Scottsdale website on that, because of course things can change, but that's what's anticipated at this point. We really recommend that you visit scottsdaleaz.gov and search short-term rental in the search engine once you're on that website. For essential information on short-term rentals in the city of Scottsdale. This is just an amazing resource for board members, property managers, owners, and owner landlords. The amount of information that the city of Scottsdale has put on this website and that provides to you is unbelievable. It's the only city in the state that I'm aware of that's doing this type great education and having it right there on their website to provide you with information. So kudos to the city of Scottsdale for doing that. Friendly reminder, all 5 of these laws that we talked about here today, they're all going into effect on September 24th. And we have a really great summary that we're going to be sharing with you. It's a summary called the 2022 Summary of Pending Arizona Legislation that was passed this year. And you're welcome to either reach out to our firm, it'll be on our website, or reach out to me personally to my email at bmulcahy@mulcahylawfirm.com if you want a copy of that. Okay, we're going to go right into questions. Looks like we have a number of great questions here today. So the first question is, does the notice of peaceful assembly need to be posted 48 hours prior to the assembly? Or does that not apply to this? So really good question. So remember, under Arizona law, open board meetings where we have a majority of the board or a quorum of the board discussing association business have to be noticed under Arizona law 48 hours in advance of the meeting. And that notice can be by posting or any other reasonable means. Most boards are posting at the common areas, putting on the website, maybe sending out an email to members 48 hours in advance of a regular board meeting. The peaceful assembly law doesn't have that specific requirement of, making the board post it 48 hours in advance. What I would suggest is, if you're a board member, when you receive the request to post the meeting, get it up in a reasonable amount of time. Okay, so don't play games, just get the notice up as quickly as possible, pursuant to the owner's request, to have the peaceful assembly meeting. If you are an owner, get the information to the board with plenty of time. So what you don't want to do to the board or the management company is at 3 o'clock on the day of the meeting, send over the request and expect that they're going to have it posted within a half an hour. That is not a reasonable expectation. So give them a few days notice or however much notice you want, and give them a reasonable period of time, a day or two, to get the notice up on the property and put it on the webpage or whatever. Because there's no specific requirements, but we want everybody to try to be reasonable and work together with this new law. Okay, next question. Let's see, HOA business, political signs regarding HOA business. If there are no pending measures or decisions in front of the board, is a political sign okay? Good question. Probably not. Because if we go back to the language of the statute, it has to be like a ballot or proposition mailed out. That's what starts the ability to post the signs regarding association issues, political signs regarding association issues on your property. So if there isn't something that is, pending that's going to be voted on by the homeowners, then no, my opinion would be that that is not something, that you can just put political signs up all the time, all year. I'm just going to go back. I'm like a detail nut, so I'm just going to go back and look real quickly. I think if you look at the specific language of the statute, let's see here. Okay, I think the only time that they can have it is, okay, so we cannot, let's see, regulate, make any other regulations. Let's see. You cannot prohibit the display of association-specific political signs between the date that the association provides written or absentee ballots to unit owners. So from the date the ballot goes out, and this is going to be something like a ballot that owners get to vote on, to the date 3 days after the election or it's being voted on, we have to allow those association-specific political signs. Any other time we can prohibit it. So if we're just at the time of the year where, there's no ballot that's being sent out for the owners to vote on, and we just want to say, put up a sign that, makes a statement about the association, you can't do that under the new law. So that's a really good question. I haven't had that one yet. So I'm glad I went back and double checked that. Okay, question number 4. In the CC&Rs, to avoid short-term rentals, should the CC&Rs specifically read no short-term rentals? We have a great cheat sheet on this topic too. It's called Amending CC&Rs and Implementing Short-Term Rental Restrictions. So I think if you're going to amend your CC&Rs, to avoid, I think that means prohibit short-term rentals, you have to be really specific in terms of what is a short-term rental. What type of rentals are allowed? Like, are you going to allow rentals that are over 60 days? And you really need to work with your legal counsel as you're structuring these CC&R amendments or interpreting what your current CC&R amendments state. Condominiums have some very special requirements if you're trying to prohibit short-term rentals or place restrictions or limitations on it. So you want to talk with your attorney for your association if you're a condo thinking about doing that. Planned communities, it's a little bit easier to do that under the Planned Communities Act. Great question. Okay, conclusion. I've got 2 minutes, Bruce. I'm on target. First class, we are on target for this class. So thank you, first of all, to the City of Scottsdale for having me today as a presenter for this class. It's always a pleasure to work with Bruce and his team at Neighborhood Services and the City of Scottsdale to provide education to board members, homeowners, and managers about how we all can follow the law better, work together as associations, and have better communities in Scottsdale. Thanks again for being with us here today. I hope everybody has a great weekend, and thanks again to Bruce and his team at the City of Scottsdale for putting on these awesome classes.